Welcome to the Power of Peacefulness Podcast. We're all about bringing peace into your life. If you like this podcast, do me a favor, give it a thumbs up. And if you need some extra help, go ahead and download my free resource. You can find that at Sharon McLaughlin, MD/workbook. It's a workbook all about peacefulness. So if you need some peace in your life, try the workbook. All right, let's get started. Hey, everybody. Today we have Dr. Richard Gajdowski with us. He is going to be talking about divorce. Rich, thank you so much for being here today. I know that you're an emergency room physician, also then went on to get your JD. You have practices in Pittsburgh and also New York, probably others that I'm unaware of. I appreciate you coming on here. I know that this is going to be very beneficial for many of you.
Yes, thanks very much for having me, Sharon. As you mentioned, my background and training is emergency medicine. I have been a physician for 40 years. Recently, I felt my life wouldn't be complete unless I went back to law school. I'm based out of Pittsburgh, Pennsylvania, but I'm also licensed in border states as well, New York, Ohio, and soon to be West Virginia. But in addition to my day job in medicine, I do have a part-time law prep, what I call a boutique law practice. I'm a veteran, so I help veterans with the veterans' legal issues, but a lot of my legal practice is family law and wills, estates, and trusts. So I have a number of clients that I assist in the divorce process and with estate planning, power of attorney, both medical and legal power of attorneys. That's a big part of what I do with my law practice.
Thank you for coming on. We had spoken before you came on about the divorce rates for physicians. Could you go through those numbers?
Yeah, the news is better than what most people might think. So if you're looking at a national divorce rate of close to 50%, the numbers are actually much more encouraging for physicians. There was a older, probably about 10-year-old, now British Medical Association journal article that looked at the issue of physicians and divorce. And the divorce rate among physicians is roughly about half that. So it's roughly about 25%. Now, within that number, female physicians are particularly at risk. And I would be the first person to say more study is needed. The demographics of physicians has changed since certainly we started practicing medicine and continues to evolve and change. And the issues of female physicians is a very dynamic area and deserves more study. But that study showed that of that 25% base rate, women have about a 50% higher risk of being divorced than their male counterparts. And one of the causative factors has to be noted in that study is hours worked. The more you work as a female physician, the more likely you are to get divorced. Now, we can only speculate about what the causative factors are and work-life balance and family balance, but the issue is that female physicians are particularly at risk. Now, clients come to me when they're contemplating or facing divorce or getting served. My advice is always, do you want to do this? Work it out. And where I practice normally in Pennsylvania, which is the majority of my clients, every state is a little bit different. I do want to preface my comments by saying that my experience and my general advice here not be constituted as legal advice. And the first advice that I would give to any of your listeners and any client is that if you're contemplating that or you're being served, seek legal advice. Doesn't have to be an expensive lawyer, but you want good, competent legal advice. And anything that I'm mentioning to you in the podcast shouldn't be construed as legal advice. You have to check what's going on in your particular jurisdiction, because every state is particularly different. Every jurisdiction is different. So what I always say is that in any client is that, do you want to do this? Have you tried to work things out? In Pennsylvania, actually, as part of the divorce process, Pennsylvania has something called a 90-day cooling off period. The fastest you can get a divorce if it's uncontested is 90 days. And there is a legal requirement to notify the other party of opportunities for marriage counseling and conciliation and so forth. So the statute and the law, what listeners need to hear is that um, the laws are construed to support the institution of marriage, to make it not terribly easy to get out of, to allow for sober second thought and reflection. But once clients are coming to me, my goal is to walk them through the process, walk through the experience. So it's daunting, it's stressful, but my goal, and hopefully in this video, I can talk about what issues that you kind of need to solve, and what things that you need to address when you're facing divorce and separation.
Okay. And what are those?
The first thing to think about is, and what I would say is that there's several challenges and several things that you have to think about when facing divorce. The first is, and ordinarily your major asset, and again, divorce is a separation of assets. So there's what I call his, hers, and ours, or hers, hers, and ours, or whatever combination of that may be applicable. So one of the major assets is the marital home. And the first thing you have to think about is who's going to live where, and what is going to be necessary. So there's only two possibilities. One divorcing spouse is going to live and buy out the other spouse, or that's not going to be possible because, in other words, one of the things that if you decided who's going to live in the house and who's going to move, that person, if there's a mortgage or balance due, then somebody has to buy the other person out. Now, in two physician families where an income is more even, that may be a possibility. And I do want to say that, and one of the statistics that I wanted to mention is the divorce rate is even lower for two physician families. So out of that 25% number, the divorce rate for two physician families is usually about half that. Now, the old paradigm of male as physician and female spouse is starting to go away a bit. But generally speaking, that's going to be your major asset. In most jurisdictions, that's considered a marital home. So the one thing you're going to have to think about is if you're staying is, can you buy out your spouse? And you're going to have to refinance. The advice I have for your viewers is, the phrase is learn to live like a resident. In other words, what you want to do is adjust your lifestyle and your expectations to account for a difference in your lifestyle. And the first thing you want to think about is, if you're going to sell the house, if you're going to live in the house, is who's going to buy who out and can they afford it? Or if that's not possible, then you have to think about where you're going to live. Now, the one thing that I want to mention for your viewers is separation does not necessarily mean that somebody has to move out. When courts look at the duration of separation, how long you have to be separated, they look at the totality of the circumstances, meaning, are you leading separate lives? Are you in the same bedroom? Are you in a different part of the house? You don't necessarily have to move out of the house in order to be considered separated. It's the facts that dictate whether you're separated or not. Now, for most people, somebody moves out or somebody stays. Now, the one legal thing that you need to think about, right, is if you are the one that is deciding to leave the marital home, you need to be prepared for the fact that you may not be able to enter your marital home even though you own it in theory, because the other spouse may put a material or legal block on you being able to enter the home whenever you please, and that affects your personal effects that you have. So it's best to kind of work that out. Now, what is also important after you've sort of figured out marital home and marital, and we'll talk about marital assets in a bit, is legal expenses. Now, generally speaking, in a divorce, every litigant, whether they're the one filing for divorce or whether they're the one getting served, is responsible for their own legal expenses. Now, if there's a great disparity in income, you're, for instance, the physician and your spouse is a homemaker and has no legal, they may end up suing you for legal expenses as well. Now, the courts will look at that depending on the earning capacity of the individuals involved. But as a general construct, you should be prepared to pay your own legal expenses. Now, the helpful tip that I have is lawyers are your advocate; they're not your buddy. So what that means is and one helpful tip I can give to your viewers is figure out what legal they charge by the fractions of the hour, and whatever that bill is going to be not insignificant. You better be prepared for it, especially if it's a contested divorce. Now, what I recommend is save and batch all of your legal questions. You're going to, when you're faced with the prospect of divorce, there's going to be 1,000 questions. Now, what I recommend is use the economy as a scale and communicate with your lawyer. Sit down and figure out what specific questions you have. Try to batch them. What I would avoid is don't try to contact your lawyer every couple of minutes when you have a new question, because all that does is increase the bill. Another way to avoid costs is think about mediation and arbitration. And one of the common questions that I get from clients is, how can I keep this legal bill as modest as possible? And what I say is, one, do a lot of your own homework, meaning, I'll get to inventory of assets, but do a lot of your own homework and come to consensus with your divorcing spouse as quickly as possible. The more you can agree on, the court is not there to take sides. And despite what is sort of commonly thought that there's a gender bias or some kind of iniquity, or courts tend to side with one parent, that's just simply not true. The courts will generally ratify any reasonable agreement between the divorcing spouses. Now, the exception to that is child support. Now, child support, you should look at child support as the interest of the child. It's the one thing that you can't negotiate away. You can negotiate anything else between the two spouses in terms of division of assets, but child support is the right of the child, and the courts will look at it that way. So something to think about. What I would say is, and most jurisdictions, and certainly where I practice in Washington County, Pennsylvania, there are mediators that you can use that are far less costly than attorneys and have a great success rate. My advice is come to consensus, and be prepared to give and take. The less you fight, the less it's ultimately going to cost, and the more asset you will have. The way to look at it is you have this pot of assets that you've accumulated in your marriage. The goal is to maximize that pot because it benefits you both. Now, what I want to say, and I assume that you have viewers from coast to coast, not all states are what we call equitable distribution states. I'll explain the difference to your viewers. There are 41 states that are equitable distribution states. There are 9 states that are what's called community property states, mostly in the West Coast, including Texas, Louisiana, Wisconsin, which is a 50-50 state. there's very little, there's basically two kinds of assets: your own personal assets and marital assets. And generally speaking, courts will look at anything acquired during the marriage as a marital asset. Now, equitable distribution states looks at a variety of factors. In Pennsylvania, for instance, there's 17 factors that you look at when you determine equitable distribution. It's not necessarily 50-50 by default. It's the earning power. It's the length of the marriage. It's what each spouse has brought in terms of contributions and assets, looking after the kids and so forth to determine what is fair and equitable. Other in community property states, California is the big one, obviously. It's a 50-50 split. And it doesn't, and community property is just that. And so whatever that, obviously for physicians, that disadvantages the high income earner and benefits the lower income earner. But those are that's the law of the land in the state. The other thing to think about is what is or is not generally considered a marital asset. As I mentioned, the marital home is a marital asset. Unless it's been negotiated prior. Now, what is not generally a marital assets? Things like inheritance. If you bring that to the table, it's generally not considered a marital asset unless you commingle funds. And what that means, that's a legal term, but what it means is that you take something that was yours, let's say an inheritance, and you use it to make a down payment on the marital home or put it in your joint account. So my advice is, if you're coming into an inheritance, if you have something that is distinctly yours, you either stipulate that in a prenuptial or postnuptial agreement, and we haven't talked about that. But there's no time limit on when you can come to a marital agreement in advance of divorce. But if you commingle funds, they're generally looked at as a marital asset. The other thing that you need to think about is the tax position of your assets. Now, prior to New Year's Day 2019, the IRS changed the tax code. And so when you paid alimony, if you were the higher income earner, you got the tax break, and the recipient of the income paid the taxes. That no longer applies. So if you're paying alimony, it's not tax deductible. It is not tax deductible, but it is taxable as like alimony is now taxable. So the lower income earner is paying the taxes, which obviously benefits the lower income earner and disadvantages the higher income earner. But that's the way it is. The other thing to think about is what is a marital asset is generally the value of your retirement that has appreciated during your marriage. You may, and so when you look at that pot of money, and again, I'm not an accountant, I absolutely recommend to all your viewers that the next sort of big pot of money or big pot of assets after you figure out how to divide your marital home is your retirement savings. So if you have a sort of a blended portfolio, and generally all of that stuff goes into a pot, and everybody takes their share. So your retirement savings and what it is appreciated during your marriage is considered marital income, and that's subject to division. Now, the one thing that I want to mention is, and this is a part of the negotiation, is your goal or your strategy should be to maximize that pot of money for the both of you to split. And specifically, and I'll give you the example, some retirement plans are tax deferred and some are tax exempt, like a Roth, for instance. So if you've got a pot of money, it makes more sense for the higher income earner to keep the tax exempt retirement money and give the tax deferred retirement money, whatever that number is, to the other spouse that's making less money, because there's going to be less tax treatment. So if you're a higher income earner and your spouse is a lower income earner, give her more assets in the tax deferred 401s and keep the raw, for instance. So it's important to consult a tax advisor or tax accountants to say, well, what is this worth after taxes, and how can we benefit? What proportion of this pot of retirement money should go to what spouse in order to maximize our tax treatment? The same thing with if you have children going forward, how can we maximize the tax benefits of health savings accounts and flexible savings accounts, for instance? Now, a family is considered you and a kid. So let's say, for instance, you have a number of children. It may make sense to split the custody of the kids, to say, okay, well, I've got one kid and you've got one kid. Now we're both families, and so we can take advantage of the tax advantages of flexible savings accounts and HSA going forward. Again, I don't want to substitute what I'm saying for tax advice, but those are the things to consider. And I'm mentioning those things to your viewers because courts won't. When courts are not going to look at your pot of retirement money that you're divvying up and say, well, what's the better tax position for each spouse? That's considered your job. So those are sort of things for your viewers to consider, that the tax treatment of that large, that usually the pension money is it's usually the major asset is the marital home and the pension money. And then, then there's personal effects and other things. Finally, I would conclude by saying, try to save some money by coming to a census of opinion on what your house is worth. In other words, you can do it simply. You can just agree that this is what it's worth and go on Zillow and say, okay, this is what the house is worth. This is where it can divide up. Otherwise, you're going to pay for an appraisal. And that may be appropriate. The one area where you absolutely want a professional appraisal is if you have a physician practice, because that is not something that you're just going to sit down with a calculator and say, okay, well, you've got inventory, you've got accounts receivable. You need a professional evaluation of your practice. And the one thing for your viewers to consider is your equity in your physician practice is a marital asset to which your spouse is entitled to. Now, what that's worth for most physicians that own practices is going to be a complicated calculation. So you need somebody professional in order to do.
Rich, I want to step back before divorce. I see a lot of questions in my community as far as infidelity. What advice would you give to the physician listening out there, a woman out there, or a male, it doesn't matter, with infidelity in their marriage, depending on the state and what should be like the next steps as far as they're going to go through a divorce? What could help them if infidelity took place?
That is an excellent question, Sharon, and it depends on the state. For instance, where I practice in Pennsylvania, Pennsylvania is not an at-fault state, meaning infidelity is one of the factors to be considered in modifying, if not eliminating, alimony. Now, what the court is going to consider is a couple of things: whether or not it occurred, and whether or not marital assets were used to support the extramarital relationship. So in many jurisdictions, the courts will absolutely consider that. And my advice is that if it has occurred, it has to be a conversation. The first conversation is that can a marriage get past it? And again, I would advise the same general advice. The marriage is breaking down, and the question to be asked is, are the soon to be divorcing spouses interested in spending the effort to reconcile? The other thing the court looks at is the time duration for infidelity, right? If it is something that has occurred in the past, and especially if the spouse is aware of it, the spouse generally can't raise it as a factor in the divorce because they are seen to have condoned the behavior. The other issue is that if the other spouse has also been unfaithful. It tends to cancel each other out. So the court will look at that. If it's something new, then the court will obviously look at it as a factor. And in Pennsylvania, there's the 17 factors that determine equitable distribution. But Pennsylvania absolutely, and other states do as well. Some states don't regard it, and your viewers have to check with their own jurisdiction. But the factors that it is, whether it weighs in on your divorce represents on the totality of the circumstances. In other words, if the other spouse is aware of it and are they just biding their time and using that as a lever to get more alimony, that's going to be looked at. So the factors are, those factors are important. The other thing that's extremely important is when you get clients that say, well, I think my spouse is cheating on me. Well, so, how much money do you want to expend to prove that fact? And do you want a circus in the courtroom? Do you have kids? Is what I say is the juice worth the squeeze? If you're simply trying to use it as a lever to get alimony, you may want to rethink the consequences of that, because as I mentioned to you earlier in this interview, the more acrimonious the litigants, the more it's going to cost. And then you have to ask yourself, what are you getting in return? Is it something that that you want to put your kids through? Is it something that you want to put yourself through? Is it something that, and then what is it that you're trying to gain? So yes, it's a factor, but an increasing number of jurisdictions, the courts view as, okay, they're not looking to punish one spouse or another. They're recognizing that the marriage is broken, and they're simply focused on the business of the division of assets.
And then in the beginning, you had mentioned leaving the house. I see a lot of questions like, don't leave the house. You mentioned the possibility of not being able to re-enter the house. Are there any other issues that you would suggest as far as reasons to stay in the house, not leave?
One of the reasons to stay is obviously the economies of scale. It gives you, if you're planning for divorce, it gives you a requisite amount of time to plan your finances. And if you're leaving the house, if you're doing it in a hasty fashion, what you have to do, especially if kids are involved, you have to adjust rather quickly to another expense. Now you're shouldering the expense of two households. Because you leave the house, that doesn't mean the next day that somehow you are now absolved from the expenses in maintaining your major marital asset, which is your marital home. So your name is likely on the mortgage. You're still going to have to pay the mortgage. And I would caution clients, and some clients have said this to me, well, I'm out of the house now. It's my spouse's, she's living there or he's living there, and she's, so she should be responsible for the mortgage and the taxes. Well, it doesn't work that way.
Okay.
As a general rule, if you're staying in the house, you're generally not going to get alimony, because when you think about the focus of alimony is it's not supposed to be a payment in perpetuity. It's a rehabilitative payment to get you back on your feet and move past your divorce and get back to a lifestyle and an earning potential that you had before the divorce. The idea that you're going to get back to that place is not really the goal. It's alimony is more meant to be rehabilitative. But there's sort of two pieces to alimony. There's alimony, alimony is the payment that occurs after the divorce is final. There's something called APL, or alimony pendent lite. So what that means is that if you're looking for alimony, you have to prove to the court that you're not able to support yourself absent the APL. It's not meant to be a windfall. It's meant to be it's divorcing. I'm not the big earner here. I can't live on my own without alimony. An APL is the term given to the alimony that's awarded before the divorce is final. So let's say you moved out tomorrow after a period of separation. You can file for APL as a payment in anticipation of the final divorce.
Rich, if anyone wants to work with you, how would they get a hold of you?
That's easy. My name's Rich Gajdowski. I don't think I'm too hard to find. My website is gajdowskilaw.com. And as I said, if anybody wants to contact me, they are feel free. There's an intake form on my website. For the record, I am as of May the 30th, I am licensed to practice law in New York, Ohio, Pennsylvania, Tennessee, and as of June the 4th, I'm being sworn in West Virginia. So those are the states I am or will be licensed to practice law. And anybody is free to contact me at gajdowskilaw.com.
This has been so helpful. Thank you very much. Rich is Dr. Gajdowski. The contact information will be in the show notes as well if you guys have a hard time, but it's spelled GAJDOWSKI law.com.
Thank you so much, Sharon.
Thanks, Rich.
Have a good day.